Good morning, everyone, and thank you very much for joining another session of the Burness Paul Junior Energy In-House Lawyers webinar series. My name is Rory Henretti, and I am a Senior Associate in Burness Paul's Energy team, focusing on M&A transactions. I'm one of today's speakers, and I'm joined by my colleagues Emily and Robbie, who are also members of our Energy M&A team. Today's webinar will focus on deal and consideration structures in renewable energies transactions. Before we get started, it's just a bit of housekeeping, please. Once you've joined, please can you ensure that your mute button has been selected to limit any background noise. Today's webinar won't be interactive, so please do contact Emily, Robbie, or myself if you've got any questions after today's session. Our contact details will be available at the end of the slides on screen. Today's webinar will be recorded, and if you have any queries about that, please do check out our privacy policy on the Burness Paul website. So one of the key features of these transactions in the renewable sector is the concept of ready to build, often shortened to RTB. Where a project is ready to build, that usually means that all of the necessary pre-construction hurdles have been overcome and a developer can actually begin work on site. These pre-construction hurdles typically include three main elements. First, you have the land rights, which means you have somewhere that you can build your project. Then you have your planning permission, which means you're allowed to build your project. And finally, you have a grid connection or a grid connection offer, meaning that you can sell your electricity from your project to the grid. In the early days of the market, if you called a project ready to build, you meant exactly that. And projects coming to the market at that point were often very close to achieving ready to build status. As the market has matured over recent years, the concept of ready to build and how buyers and sellers deal with achieving ready to build in a transaction has evolved. When selling or acquiring an early stage project, there is a lot to think about. In particular, you will need to consider whether a transaction structure that reflects your chosen project stage of development. As the steps required to achieve ready to build status are subject to the control of third parties, there's no guarantee that a project will ever reach ready to build status. For example, planning consent will need to be determined by the relevant planning authority, and the negotiation of land rights will often involve one or multiple landowners. Buyers and sellers are therefore looking at different ways to balance the risk of a project not reaching RTB through the structuring of their transaction. Another common feature of energy transactions that I'll mention briefly is the potential requirement to notify the transaction to the government under the National Security and Investments Act 2021. This is because energy is one of the regulated sensitive sectors that falls within the scope of the NSIA. For more information on NSIA, please refer to our earlier webinar on this topic, which you can access via the webinar series page on our website. So bearing all of that in mind, today we're going to look at the different transaction consideration structures that parties will look to use to cater for the relevant stage of development of the particular project or projects which are being acquired. These include a split signing and completion structure, a deferred consideration structure, and also staged acquisitions. We'll focus mainly on the split signing and completion and deferred consideration deal structures, and then we'll briefly touch on staged acquisitions, which are much less common. I'll now hand you over to my colleague Emily, who's going to take you through split signing and completion.
Thanks, Rory. So a split signing and completion means the parties enter into a conditional contract where the buyer and seller are required to complete the acquisition once a set of conditions are satisfied. As we touched on earlier, completion conditions for energy transactions typically relate to achieving ready to build, including, for example, the target obtaining land rights, planning permission, or a satisfactory grid connection offer for the project that's being sold. The share purchase agreement or asset purchase agreement should set out which party is taking on responsibility for the satisfaction of each condition to completion. Generally, in energy transactions, it will be the target and the seller that's responsible for satisfying the conditions. Satisfying the conditions are to some extent out with the control of the target and the seller, as they tend to rely on third-party approvals, for example, from the local authority in respect of planning permission or the relevant network operator providing a grid connection offer or agreement on terms that are beneficial for the development of the project. If you're acting on the sales side of a project, you should consider the extent to which the seller and the target have control over the satisfaction of the condition in the context of their obligations to procure their satisfaction. So moving on to interim period restrictions. It will be important for a buyer to ensure that it receives appropriate contractual protections relating to the running of the target business in the gap period between exchange and completion. These are often referred to as interim period restrictions or conduct of business provisions. Typical restrictions include requiring that the sellers carry out the business in the ordinary course and requiring the sellers to covenant that they won't take certain actions without the consent of the buyer. Examples of these restrictions include incurring capital expenditure above specified thresholds, granting any guarantees or securities, commencing any legal proceedings, selling or disposing of any material assets, terminating any material agreements, hiring any employees, and any actions that would result in the termination or withdrawal of a grid connection offer or the project planning permission, or anything that would prejudice the approval of the planning application. Typically in energy transactions, the target business will not be a trading business, therefore the strict restrictions should be tailored to reflect that. If a business is subject to interim period restrictions, it's important to communicate with all internal stakeholders that might be impacted to ensure the restrictions are adhered to and consents are obtained where necessary, for example, in relation to incurring expenditure or entering into contracts. So moving on to warranties. The share purchase agreement or asset purchase agreement will include a suite of contractual warranties in relation to the target or assets being acquired by the purchaser. In a split signing and completion deal, the buyer will want to make sure that the warranties are given at exchange and then also repeated at completion. Repeating the warranties at completion means the buyer has protection from the sellers in relation to events occurring post-exchange but pre-completion. Without a repetition of the warranties, the buyer would be assuming the risk for the events occurring during the gap period where they don't have control of the running of the business. Where sellers are required to repeat the warranties at completion, a further disclosure exercise will be required involving the sellers or the warrantors again going through the warranties to determine whether any new disclosures need to be made. The sellers will then provide the buyer with a completion disclosure letter, which should take the same form as the exchange disclosure letter as negotiated between the parties, subject to the inclusion of any new specific disclosures relating to the gap period. The sellers should be made aware at the outset of the transaction of the need to repeat the disclosure process at completion. Warranty and indemnity insurance may be put in place to provide cover for warranty claims. Most commonly, W&I cover is taken out by the buyer, meaning it will pursue the insurer in the event of a claim rather than the sellers, with the seller's liability typically being capped at £1, say for instances of fraud and any other exclusions. If W&I cover is in place, the disclosure process will need to be repeated at completion for the benefit of the policy. W&I cover becomes more complicated for interim period issues and new breach cover is very technical. Essentially, W&I policies will usually not provide cover for breaches which both arise and are discovered during the gap period. However, cover is often available for warranty breaches which occurred pre-signing but were only discovered after signing. We will discuss W&I insurance further at our next webinar. So moving on to termination provisions. In a split signing and completion deals where completion is conditional on certain conditions being satisfied, the share purchase agreement or asset purchase agreement should set out the acquisition will terminate in the event that the conditions aren't satisfied by a specified long stop date, unless the parties agree to extend the date. As we mentioned previously, usually the conditions require to be satisfied by the sellers. Therefore, depending on the nature of the condition, the buyer may want to include a waiver right, which allows them to waive the condition, meaning the acquisition can complete without the condition being satisfied. From a buyer's perspective, split signing and completion deals create a risk that the target business that they're acquiring significantly reduces in value during the gap period due to certain market forces. And notwithstanding that, they are still tied into completing the purchase if the specified completion conditions are met. One way of protecting against this risk is by including a material adverse change clause, also known as a MAC clause. This allows the buyer to walk away from the transaction in the event that the target suffers certain materially adverse changes during the gap period. This is a buyer-friendly provision and not one that we see too often, as it places much of the risk back on the sellers and therefore it tends to be heavily negotiated. If you are on the sales side, you should seek to negotiate the terms of the MAC clause carefully to ensure that the buyer can only trigger an exit in very limited circumstances. In terms of a breach of warranty, in addition to the right to terminate the share purchase agreement or asset purchase agreement for failure to satisfy the condition, buyers will sometimes seek a termination right in the event that a breach of warranty or interim period undertaking is discovered in the period between exchange and completion. In practice, often we see this leading to discussion on whether the breach is material or not, and often circumstances which constitute a breach of warranty claim also constitute a breach of interim period undertakings, so the two should be considered alongside one another. In terms of the effect of termination, if the asset purchase agreement or share purchase agreement is terminated, this means the buyer will not acquire the target or the target assets, which will remain in the ownership of the seller. All rights and obligations of the parties under the transaction documents will then usually cease, other than confidentiality obligations or accrued rights. In some circumstances, parties may look to include provision for cost recovery in the event that an acquisition doesn't go ahead as a result of one party failing to satisfy a condition. This tends to be more relevant for buyers who are relying on the sellers satisfying certain conditions, and it will be a point of negotiation between the parties, and the sellers will be reluctant to agree to onerous provisions relating to a buyer's fee, especially where the satisfaction of conditions are to some extent out with their control, for example, where approval is needed from the relevant planning authority or local authority. I'll now pass over to Robbie, who's going to discuss deferred consideration structures.
Thanks, Emily. So as we've mentioned, renewables transactions often involve the acquisition of assets at different stages of the development cycle. So deferred consideration can be used to address the achievement of development milestones. Deferred consideration means that payment of some or most of the acquisition price is deferred until a future event occurs, such as the achievement of a development milestone. In a deferred consideration transaction, these milestones typically occur after completion, so the buyer will have ownership of the assets or shares in the project SPV before the deferred payments become due. This reduces risk for the buyer, who only pays the full acquisition price if the project moves forward and/or does so on the basis of improved development characteristics, such as increased capacity, more efficient equipment or infrastructure, or an earlier grid connection date. This in turn guarantees that the seller has an incentive to support the development process post-completion. Some examples of the types of future events that will trigger a deferred consideration payment are the project obtaining land rights, planning permission, or satisfactory grid connection terms. For example, in relation to planning, the project might have obtained some or all consents, but sometimes consent is pending at closing, or a variation to an existing consent is awaited, which would make the project a more viable or productive asset. For example, increased tip heights for turbines, or the addition of turbines or another technology to the development. Consent under the Planning Scotland Act 1997 for Scottish transactions and development consent orders, or DCOs, in English transactions are used to manage regulatory and planning risk, especially for projects like large wind farms, solar parks, nuclear facilities, or grid infrastructure. The process is often lengthy from application to decision. Therefore, a buyer will often not wish to make payment of the full acquisition price while this process is ongoing. Another example is participation or success in government subsidy-related mechanisms or clearing regulatory hurdles. Examples of this include the contract for difference and capacity market regimes, or more recently in respect of the connections reform process in respect of the grid connection queue. Here, a buyer may seek to incentivise the seller to accelerate the development of a project in order to gain entry to a relevant subsidy auction, the result of which would make the project more financially viable and or lucrative for a developer should it benefit from the relevant government-backed subsidy. Alternatively, having deferred consideration linked to achievement of specific grid connection related milestones is common, including obtaining revised terms which result in increased capacity, an earlier grid connection date, or a change to the technologies used in the connection, all of which may have a positive impact on the revenue and viability of a project, and therefore worthy of a deferred consideration or premium if achieved. The final example is project performance, such as capacity and production targets, which are used in the renewable sector. However, this is not something we see as often in M&A transactions and documents, and is something you're more likely to see in the property documents for renewables transactions, such as in an option agreement. However, you may occasionally see performance-based structures used in M&A transactions involving trading businesses, rather than those in early-stage project SPVs. So how does a deferred consideration payment work in practice? As I've mentioned, a deferred payment is a conditional payment, so it is contingent on a particular event taking place. This means that the payment structure under the share purchase agreement or asset purchase agreement will be set out as follows. Upon completion of the acquisition, the buyer pays an initial amount of consideration and ownership of the shares or assets is transferred to the buyer. Then, at a point in the future, when the relevant deferred consideration condition or milestone is achieved, such as the granting of planning consent, the corresponding deferred consideration will become payable. Like the conditions Emily mentioned earlier, deferred consideration conditions may not always be achieved. For that reason, a long stop date for the achievement of the deferred consideration condition is often included. As you will appreciate, the inclusion of a long stop date can therefore provide an additional incentive for a seller to assist in the development of the project and to swiftly fulfil the deferred consideration conditions. So, where a deferred consideration mechanism is used, a number of additional provisions sit alongside the payment mechanics to assist in allocating risk between the parties. In particular, a seller will wish to have comfort that it is going to receive the payment when it fulfills the conditions for the deferred consideration, and a buyer will look for protection for a change in circumstance by the time a deferred consideration payment becomes due. So as a seller will be transferring the shares in the project SPV or transferring the project assets at completion, the seller will lose control of the asset without having received full consideration in return. As a result, the sellers will need to be comfortable with the buyer's financial health to ensure they are able to make the deferred payments in question. An undertaking from the buyer may be sought by a seller that the buyer will have sufficient funds at the relevant time to pay the deferred consideration. The seller's concern being that the buyer becomes insolvent, the buyer siphoning off assets before payment is due, or even the buyer's group restructuring in a way that isolates liabilities. In circumstances where the seller is not comfortable with the buyer's financial standing, the seller may seek a guarantee or an equity commitment letter from the buyer's parent company. This means that if the deferred consideration became payable and the buyer was unable to pay, the seller would be able to pursue the parent company under the parent company guarantee, or PCG, to receive payment. PCGs can often be resisted by buyers, and careful consideration should be given by a buyer and its parent as to what the PCG will cover. From the buyer's perspective, it would ideally be restricted to guaranteeing the obligation to pay the deferred consideration and no other obligations of the buyer. In energy M&A transactions, set-off is a contractual mechanism that allows one party, usually the buyer, to offset money they owe to the other party, usually the seller, with amounts that the other party owes them. For example, in a scenario where a breach of warranty has occurred, or if an indemnity claim arises before the deferred consideration becomes payable, the set-off mechanism would allow the buyer to withhold or reduce the deferred consideration payment to the other seller because the seller owes the buyer an amount in respect of that warranty breach or indemnity claim. The benefit of including this right for a buyer is that they have a more immediate right of remedy against the seller. Instead of having to pursue the seller for payment, they can simply reduce or withhold the amount that they are due to pay to the seller themselves. Set-off provisions are often heavily negotiated, as a seller will not wish for a buyer to make spurious claims to withhold payments, which are otherwise due to the seller. For example, an expert determination mechanism might be used, whereby the buyer must evidence that they have a valid claim before withholding payment. In the case of a warranty claim, that may involve obtaining the opinion of a KC on the merits of the proposed warranty claim. Escrow arrangements can sometimes be a feature of deferred consideration transactions. An escrow is a financial arrangement where the deferred consideration is held by a neutral third party or escrow agent on behalf of the buyer and seller for a defined period after closing. The funds will then only be released to either the buyer or the seller where strict conditions are met, similar to those I've just mentioned. This provides some comfort to the seller, as the deferred consideration funds are ring-fenced and cannot be spent elsewhere by the buyer assisting with the credit risk concerns. Using an escrow can also be beneficial for a buyer in implementing a set-off provision, as mentioned previously. Overall, an escrow can be beneficial to both parties in demonstrating good faith and willingness to make payment and/or fulfil conditions, which can help in concluding negotiations. I will now pass back to Rory, who's going to discuss staged acquisitions.
Thank you, Robbie. As an alternative, but much less common approach to dealing with early stage developments, a buyer and seller may look to implement a staged acquisition structure. This will involve the buyer acquiring an increasing stake in a project SPV upon the achievement of project milestones. This method can be helpful for a smaller developer who wishes to partner with a larger developer who may be able to provide assistance to develop the project. For example, by providing funding or technical or operational support to progress the development of the project, with the ultimate aim of ownership at the ready-to-build stage. This can be particularly attractive for developers who may have a portfolio of potential projects without the resource to develop all of them. Similarly, for larger developers, this may provide access to a development pipeline without significant capital outlay in the early stages. Entry into a staged acquisition process will result in a joint venture relationship between the buyer and the seller, and as a result of this, it is a significantly more complex structure. It will involve additional legal documents, such as shareholders' agreements and articles of associations, to regulate the relationship of the parties, and this relationship will also be fluid, as the buyer's stake in the SPV will likely increase over time, and this will lead to different rights and obligations being applicable at different times during the relationship. In addition, security arrangements may also be put in place to protect the buyer's position as a minority shareholder. Parties will often need to consider how to exit from this arrangement, either because the project is not proceeding as intended, or because the priorities of the parties have changed over the course of the development. This may lead to the parties including a put option and/or a call option, and all of these different provisions require additional negotiation, additional documentation, thus making this a much more complex structure. As a result, we see these arrangements less frequency than split signing completion transactions or deferred consideration structures. However, if you'd like to know more about a joint venture and how partners in a joint venture regulate their relationship, please see our earlier webinar on joint ventures on the webinar section of our website. So what does this mean for you, and what aspects should you bear in mind when you're involved in a transaction of this type? For split signing and completion transactions, if you're on the sell side, it's really important to consider the interim period restrictions and how these will affect the target during the period between signing and completion. You should really be putting yourself in the shoes of the buyer and making your internal stakeholders aware of what actions are permitted or which might require the consent of the buyer during the interim period. For example, Any restrictions on entering into contracts or incurring costs might require consent. Again, on the sell side, you should also be making stakeholders aware that they will be likely required to repeat warranties at completion and should be prepared to undergo a further disclosure process. This can be a time-consuming process involving various different teams across your business, so preparation and communication is key here. It's important for parties to consider how the landscape might change during the period between signing and completion, particularly where this is a long period. Depending on the nature of the business and the risk factors that impact it, you should carefully consider material adverse change provisions, whether as a useful escape route if you're in the buyer side, or as a potential deal killer where you're a seller. Where a deferred consideration transaction structure is implemented, sellers should bear in mind the creditworthiness of the buyer and its ability to make payment after you've given over control of your assets or shares. Your finance colleagues will likely be keen to understand the various protections you can seek, such as an escrow or a parent company guarantee. That now brings us to the end of today's session, but if you'd like to hear more about any of the topics covered today, or if you have any specific queries for us, please do reach out to one of the team. We'd be delighted to hear from you. As discussed, our session today has been recorded and you will shortly receive an email with a link to the recording of the session. In that email, you'll also find a link to register for further sessions and learn more about the programme. Please do use the link to check out upcoming sessions and book your spots in advance. Our next session is on Thursday, the 30th of October, and will focus on grid connection and regulatory updates. Thank you very much for joining today's webinar, and we look forward to seeing you at our future sessions.